Today we will see a very interesting case where the Supreme Court of India answers the question whether the scheme of the Insolvency and Bankruptcy Code contemplates that the sum forming part of the resolution plan should match the liquidation value or not. Now, this was examined in the case of Maharashtra Seamless Limited versus Padmanabhan, Venkatesh, and others. This judgment was released by the Supreme Court on 22nd January 2020. Let us look at the facts of the case. Now, these proceedings arise out of the corporate insolvency resolution process involving a company by the name of United Seamless Tubular Private Limited, which in our case is the corporate debtor. The successful resolution applicant is Maharashtra Seamless Limited, and Maharashtra Seamless Limited is an appellant in civil appeal number 4242 of 2019. Now, you must remember that there were two appeals in this matter. One, 4242 of 2019 by Maharashtra Seamless, and the second one, 4967 and 4968 of 2019, filed by two other companies, which we shall see later on. So this is a common judgment in these three appeals. Now, the corporate debtor owed a total of 1897 crores, out of which 1652 crore comprised of term loans from two entities of Deutsche Bank, namely DB International Asia Limited and Deutsche Bank AG Singapore branch. There was also debt on account of working capital borrowing of rupees 245 crore from another bank, being Indian Bank. Indian Bank hauled this company to CIRP under Section 7 of the IBC. DB International Asia Limited is the appellant in 4967 and 4968 of 2019. Now, a concern by the name of UMW had provided corporate guarantee to Deutsche Bank Singapore as collateral to the said term loan. So here you can see there are three appeals: CA 4242 of 2019, in which the appellant is Maharashtra Seamless Limited (MSL). CA 4967 and 4968 was by DB International Asia Limited. Now, the adjudicating authority in this case was the NCLT Hyderabad bench. Now, on 21st January 2019, it approved the resolution plan submitted by Maharashtra Seamless Limited in an application filed by the resolution professional. This resolution plan included upfront payment of rupees 477 crores. Ancillary directions were issued by the adjudicating authority while giving approval to the said resolution plan, with the finding that the said resolution plan met all the requirements of Section 32 of the IBC. Now, this order was carried up in appeal before the NCLAT by two persons who were parties to before the NCLT. They were one of the promoters of the corporate debtor, namely Padmanabhan Venkatesh, and of course Indian Bank. So an appeal was made to the NCLAT out of the order which arose from the NCLT dated 21st January 2019. Now, in the NCLAT, there were two appeals. One was 128 of 2019, the appellant being Padmanabhan Venkatesh, one of the promoters of the corporate debtor, and the second one being 247 of 2019, the appellant being Indian Bank. Another appeal was, namely 220 of 2019, was filed by Maharashtra Seamless against the order of the adjudicating authority passed on 28th Feb 2019. So please note that 128 and 247 are against the order of 21st January 2019. 220 of 2019 is an appeal against the order of 28th February 2019. Now, let's look at the case in NCLT Hyderabad, where Indian Bank, under Section 47 of the IBC, hauled the corporate debtor to CIRP, that is the Corporate Insolvency Resolution Process. Now, this was numbered as CPIB number 49/7/Hyderabad Bench of 2017. In this petition, interim application number 125 of 2019 was filed by Maharashtra Seamless Limited. In this application before the NCLT Hyderabad, MSL sought directions upon the corporate debtor and also police and administrative authorities for effective implementation of the resolution plan. The grievance of Maharashtra Seamless was that they were not being given access to the assets of the corporate debtor. Now, what was the order of the NCLT Hyderabad in interim application 125 of 2019? The NCLT Hyderabad directed that even though the appeal is preferred by the respondent number 5 to the Honorable NCLAT, there is no stay and the appeal is coming for hearing on the 7th of March 2019. The implementation of this plan is subject to the outcome of the appeal. Therefore, a direction can be given to the concerned to extend cooperation to the applicant herein in implanting the resolution plan of the corporate debtor company. And it is only subject to the outcome of the appeal which is pending before the Honorable NCLAT. It further held that a direction cannot be given to the superintendent of police and collector because by the date of the applicant has not deposited the bid amount. Therefore, at the first instance, direction can be given to all concerned of the corporate debtor company to extend all cooperation to the applicant. It is always open to the applicant to approach the tribunal for suitable direction if so required. It further held that as a result, the application is disposed of directing the concerned of the corporate debtor company to extend all cooperation to the applicant herein in implementing the resolution plan, and it is open for the resolution applicant to approach the tribunal for necessary direction subsequent to this order if so required. Now, let's look at the order of NCLAT which was dated 8th of April 2019. Now, as per the order, paragraph 45, Messrs. Maharashtra Seamless Limited, who was the successful resolution applicant, has taken the plea that out of the verified claims of rupees 2,88,948, and it is willing to pay the verified operational creditors at the same percentage as that of the financial creditors. So, they will be paying the operational creditors 25% within 30 days of the successful resolution applicant getting clear and unfettered possession of and rights to the corporate debtor. Now, 25% of the verified claim was of 2,288,948. 25% works out to 50,72,237. Now, this is the verified claim of the operational creditors. We have seen earlier that the financial creditors claim was 1897 crore rupees. Plus there are some other claims. So totally it works out to 578 crores. 578 crores is 25% of the claims against the company. Now, this 578 crores is very much less compared to the liquidation value of the corporate debtor, which worked out to be 597.54 crores. Therefore, the NCLAT held that we are of the view that Maharashtra Seamless Limited should increase upfront payment of 477 crores as proposed to the financial creditors, operational creditors and other creditors to rupees 597.54 crores by paying an additional 120.54 crores approximately to make it at par with the average liquidation value of 597.54 crores. So if you remember, Maharashtra Seamless was willing to pay 477 crores upfront as 25% of their dues towards not their dues, 25% of the dues of the corporate debtor to financial creditors and operational creditors. Now, if the upfront amount is increased, this is what the NCLAT held, that if the upfront amount is increased to rupees 597.54 crores, the total amount should be distributed amongst the financial creditors and the operational creditors at the same ratio as suggested. As per suggestion of the resolution applicant, the operational creditors can be given the same percentage of amount as allocated to financial creditors. NCLAT further directed that if the resolution applicant fails to undertake this is Maharashtra Seamless. If Maharashtra Seamless fails to undertake the payment of an additional rupees 120.54 crores in addition to the 477 crores, thereby raising it to 597.54 crores and deposit the amount in escrow within 30 days in such case, the impugned order of approval of resolution plan is to be set aside. Thereafter, adjudicating authority will pass whatever appropriate order in accordance with the law. Now, so far as the appeal of Maharashtra Seamless, remember Maharashtra Seamless also had appealed. So far as the appeal of Maharashtra Seamless Limited before the appellate authority is concerned, the same had direct correlation to the other two appeals. In the present case, we find that the resolution plan is against the statement and object of the IBC, and therefore we have directed Maharashtra Seamless Limited to modify the plan. Please understand that where is all this coming from? Maharashtra Seamless said they would give 477 crores upfront. Liquidation value came to 597 odd crores. NCLAT said, sorry, this was not acceptable. It goes against the statement and object of the IBC, and therefore asked Maharashtra Seamless to modify the plan. And they further directed that till the plan is modified as ordered above, Messrs. Maharashtra Seamless Limited cannot take over the corporate debtor without complying with the direction as given and recorded above. Now please remember that this is the order dated 8th April 2019 of the NCLAT. It continues. However, it does not mean that the promoters / ex-directors will create hindrance in the matter of taking over the premises and plant of the corporate debtor, which for the present should be taken over by the resolution professional. The adjudicating authority, that is the NCLT, Hyderabad, will direct the resolution professional to take over the possession of the plant and offices and other premises and assets of the corporate debtor to ensure that the assets remain intact if the plan is approved by the resolution applicant in a manner directed as above. Now, for taking over such possession, the adjudicating authority will direct the concerned district collector, superintendent of police of the district to provide necessary force to enable the resolution professional to take over the premises and plant of the corporate debtor and all the movable and immovable assets. If the resolution applicant modifies the resolution plan as ordered above and deposits 120.54 crores within 30 days by improving the plan, the adjudicating authority will allow Maharashtra Seamless Limited to take over possession of the corporate debtor, including its movable and immovable assets and the plant. On failure, of course, the plan approved in favor of Maharashtra Seamless is deemed to be set aside, and the adjudicating authority will pass appropriate order in accordance with law. Now, the matter went to Supreme Court because what's happening is Maharashtra Seamless does not want to pay this extra 120 crores. NCLAT directed the NCLT accept Maharashtra Seamless's bid in the event that they pay up 120 crores and make the value offered by them equal to the liquidation amount. Of course, Maharashtra Seamless did not agree to this, and they filed interim application 115118 of 2019 in the Supreme Court. What did they want by this application, Maharashtra Seamless? Maharashtra Seamless sought refund of the sum deposited in terms of the resolution plan along with interest. In this application, Maharashtra Seamless Limited has also applied for withdrawal of the resolution plan. So Maharashtra Seamless says, sorry, I don't want to have anything to do with this resolution plan because I have to pay 120 crores extra. So they want to now withdraw. Not only do they want their 477 crore withdrawn, they want it with interest, and their grievances are such that in order to take over the corporate debtor, they had availed of substantial term loan facility and deposited the sum of rupees 477 crores for resolution of the corporate debtor in a designated escrow account on 19th February 2019. But because of delay in implementation of the resolution plan, they were compelled to bear the interest burden. It is also their case that the export orders they had accepted in anticipation of successful implementation of the resolution plan were cancelled, as a result of which the takeover of the corporate debtor had become unworkable. Now, let's look at the proceedings, what exactly happened in the NCLT. Indian Bank hauled the corporate debtor to under section 7 of the IBC on 12th June 2017. As per the IBC, interim resolution professional was appointed. Later on, it was changed to the resolution professional. The resolution professional on 10 January 2018 issued invitation calling applications from interested parties by 28th Feb 2018. Now, this timeline was subsequently extended from time to time, and altogether 4 resolution plans were placed before the Committee of Creditors. This committee was constituted on 18th August 2017. Remember, 12th of June, the petition was admitted in the NCLT. 12th June 2017, 18th August 2017, COC was, that Committee of Creditors was formed by the interim resolution professional. There were 4 plans which were taken up by the COC, and one of the plans was that of Maharashtra Seamless Limited. The other resolution applicant was Messrs. Area Project Consultants. Now, Maharashtra Seamless had offered upfront payment of rupees 477 crores. The resolution plan of Maharashtra Seamless Limited was approved by financial creditors having 87.10% of the voting share. The voting block consisted of the 2 aforesaid Deutsche Bank entities. The Deutsche Bank International Asia Limited had 73.40 vote share, and Indian Bank had 12.9% voting share in the Committee of Creditors. Now, in the proceedings before the NCLT, 2 registered valuers, being K. Vijay Bhaskar Reddy and P. Madhu, were initially appointed for determining the value of the corporate debtor. Their valuations came to rupees 681 crore and rupees 513 crore, respectively. Now, on account of substantial difference in their valuations, the committee appointed a 3rd valuer, Duff and Phelps. They valued the corporate debtor at 352 crores. Obviously, this was very less compared to 681 and 513 crores, and so the committee thereafter took into consideration the average of the 2 closest estimates of valuation by P. Madhu and Duff and Phelps, and the liquidation value was increased to was assessed to be rupees 432.92 crores. So initially, the liquidation value is assessed at 432.92 crores. Subsequently, an application was filed before the adjudicating authority by the resolution professional in which he sought approval for the resolution plan. That application was disposed of by the NCLT Hyderabad by an order dated 28th September 2018, which directed the resolution profession to redetermine the liquidation value of the corporate debtor by taking into account consideration of the first and second valuation, that's P. Madhu and Vijay Bhaskar. Now, what was the direction of the order dated 28th September 2018? The resolution professional shall convene a meeting of the COC to place the qualified resolution plans along with resolution plan of MSL before the COC for reconsideration in light of the revised liquidation value of the corporate debtor company. 30 days time is excluded from CIRP period with effect from today for completing the above direction. The resolution professional is directed to allow directors/suspended board to participate in the COC meetings and permit them to express their views and suggestions and record the same in the minutes of the COC. Now, the revised valuation of the corporate debtor was made, enhancing the same to 597.54 crores from 432.92 crores. In the 9th meeting of the COC held on 16th October 2018. Now, in this meeting, the committee took into consideration the revised valuation and on majority voting approved again the resolution plan of MSL. The directors of the suspended board were given an opportunity to express their views and suggestions before the committee. Now, 28th September 2018, the order was passed by NCLT Hyderabad to increase the liquidation value from 532 crores to 597 crores. This, of course, was challenged in the NCLAT by MSL, and this was registered as number 637 of 2018. Now, that appeal came to be disposed of on 12th November 2018. These were the directions. Learned counsel, appearing on behalf of the member of the Committee of Creditors, submits that during the pendency of this appeal in compliance of the order of the adjudicating authority, revised liquidation value was taken into consideration by the COC, wherein after the resolution plan of the appellant, that's Maharashtra Seamless Limited, has been approved. It is also accepted by the learned counsel appearing on behalf of the resolution professional and learned counsel appearing on behalf of the appellant, that is Maharashtra Seamless. In view of the aforesaid possession, we are not inclined to deliberate on the question as raised in the present appeal, which may be answered in some other case. The adjudicating authority is now required to pass an order under Section 31 of the IBC without granting unnecessary adjournments to any of the party uninfluenced by its earlier order, which is unchallenged. The appeal is disposed of with the aforesaid observations and directions. Now, before the disposal of Company Appeal number 637 of 2018, on 25th October 2018, the resolution professional filed an application being interim application number 472 of 2018 before the adjudicating authority seeking approval of the resolution plan as per the decision in the 9th meeting of the committee held on 16th October 2018. Now, if you remember, the 9th meeting of the committee held on 16th October 2018 sought to revise the liquidation value of MSL from 532 crores to 597 crores. This went as per the order of the NCLT. That order of NCLT was challenged by Maharashtra Seamless in the NCLAT. NCLAT said, you go ahead with the order under Section 31. So, the order of the adjudicating authority was issued on 21st January 2019, approving the resolution plan upon considering Section 31 of the IBC. Now, what was the order of NCLT Hyderabad dated 21st January 2019? The resolution professional has filed a present application enclosing the minutes of the 9th COC. The question whether the plan submitted by Messrs MSL is in conformity with Section 32 of the Code. If it is in conformity, then the plan is to be approved under Section 31 of the Code. The COC has examined all eligible resolutions plans again in the 9th COC meeting on 16th October 2018. The resolution plan submitted by Messrs MSL is below the revised liquidation value. The difference is 120 crores. However, as per directions of the Honorable NCLAT, this tribunal is to decide the plan filed by Messrs Maharashtra Seamless Limited without being influenced by its previous order. The COC has approved the resolution plan submitted by MSL with a majority of voting share of financial creditors at 87.10%. COC in its wisdom has approved the plan. No doubt, Indian Bank and other financial creditors have voting share of 12.9% opposed for approval of the resolution plan. The minimum required percentage of voting for approval of the resolution plan as per the latest amendment is 66%. And in this case, the resolution plan of voting share is 87.10%. The plan was approved. Now, another contention raised was the upfront payment is below the revised liquidation and therefore the plan could not be accepted. On the other hand, Honorable NCLAT has held in Company Appeal number 637 of 2018 that this tribunal is to decide the application under Section 31 of the IBC without being influenced by its previous order. Now, when such is the case, the revised liquidation value has no role to play while considering the resolution plan submitted by MSL. The tribunal has to test the resolution plan with reference to provisions of Section 32 of the IBC. The resolution professional certified that plan of Messrs MSL is in conformity with provisions of Section 32 of the Code. So, the liquidation value prior to redetermination, if taken into account, the upfront payment offered by MSL is over and above the liquidation value. Remember, the liquidation value came in at 532 crores. MSL offered 477 crores. Now they are, after reworking on the liquidation value, the new liquidation value is coming to 597 crores. Therefore, the objection taken by the director of the suspended board and also Indian Bank could not be taken into account in view of the direction of the Honorable NCLAT. So NCLAT has told the NCLT, you go ahead under Section 31, you pass the plan under Section 31, do not take our previous order into consideration. And so NCLT Hyderabad passes this plan under Section 31 of the IBC. Now, the next contention raised that the resolution applicant has not obtained prior approval of the Competition Commission of India as required under Section 31 subsection 4 of the Code. The Counsel for the Resolution Professional would contend that there is no need to obtain prior approval of the Competition Commission of India as the plan submitted by MSL does not fall under the provisions of the Competition Commission of India. The director of the suspended board has raised the same objection in the 9th COC meeting and it is answered that such approval is not necessary. Even otherwise, Section 31 subsection 4 provides that necessary approval required under any law for the timing in force is to be obtained by the resolution applicant within a period of 1 year or within the prescribed time under such law. Therefore, the resolution applicant can obtain necessary approvals in a period of 1 year if it is required. Thus, the resolution plan of Messrs MSL filed by the resolution professional is to be approved as it meets the requirements of Section 30 subsection 2 of the IBC. Now, the following flows from the approval granted by the NCLT to the resolution plan. Because it is approved, the same shall be binding on the corporate debtor, its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. The revisal plan of the company is in accordance with the approved resolution plan shall come into force with immediate effect. Moratorium order passed by this tribunal under section 14 shall cease to have vacated. Resolution professional shall forward all records relating to the conduct of the corporate insolvency resolution process and the resolution plan to the Insolvency and Bankruptcy Board of India to be recorded on its databases. Now, therefore, CA 472 of 2018 in Company Petition Insolvency and Bankruptcy number 49/7 of the Hyderabad Bench 2017 is disposed of in terms of the above. Now, this interim application was disposed of. Resolution plan was passed by NCLT Hyderabad. Of course, the promoter, one of the promoters, that is Padmanabhan Venkatesh, did not like the plan being passed, and he approached the NCLAT on the ground that the approval for the resolution plan amounting to rupees 477 crores was giving the resolution applicant windfall, as they would get assets valued of 597 crores at a much lower amount. So Padmanabhan is saying basically 597 is liquidation value, 477 crores is offered by Maharashtra Seamless. Obviously, Maharashtra Seamless is gaining the differential amount, 120 crores. The other ground urged by Indian Bank, the second entity appealing to the NCLT against the order of the NCLT Hyderabad, was the bank, Indian Bank, which said that the other resolution applicant, namely Messrs. Area Project Consultants Private Limited, had revised its offer to 490 crores, which of course was more than the 477 crores offered by MSL. So Indian Bank is saying Messrs. Area Project Consultants is giving 490 crores, MSL is giving 477 crores, therefore consider the amount given by Area Project Consultants Private Limited. And on these two grounds, the appeal was filed before the NCLAT. Now, in the course of hearing of the appeal, it appears that the successful resolution applicant had indicated infusion of more funds, which was taken into consideration by the NCLAT. This would appear from the following passage of the order of the NCLAT under appeal before us. When he's talking about us, means this case is before the Supreme Court. Now, it was submitted that actually the total exposure of the successful applicant is around 657 crores. Remember, the revised bid was 490 crores. On paper, MSL was giving 477 crores, but actually it was 657.50 crores. The addition of 180.50 crores would be infused directly in the corporate debtor by Messrs. Maharashtra Seamless Limited. Further, 57 crores would be infused towards 25% margin money of working capital expenditure. Moreover, in fact, the total working capital of rupees 224 crores, the balance to be taken as a loan from bank, would also require corporate guarantees from the fourth respondent, that is MSL. It was further contended that the corporate debtor plant has been lying closed for the last 3 years. Additionally, in all its operational life prior thereto, the corporate debtor over the period of 7 years could not produce a total of 150,000 metric tons, which is supposed to be its production capacity in 1 year. Thus, it was only after due and in-depth consideration, including taking into account extensive further investments which would mandatorily have to be made to get the corporate debtor up and running, that the successful resolution applicant offered rupees 477 crores, which was payable within 30 days of the approval of the plan. Therefore, according to the counsel of the fourth respondent, that is MSL, the aforesaid infusion of funds by MSL aggregating to 657.50 crores is for maximization of the assets of the corporate debtor. The NCLAT, however, found the reasoning of the adjudicating authority flawed. Okay, for the following reasons. And it said that therefore it is clear that the committee of creditors has also accepted that the average liquidation value, which comes to 597.54 crores, and on the basis of the resolution plan was considered. If the resolution plan is considered, then it will be evident that 25% of the admitted dues of the financial creditors have been allowed in the resolution plan. On the other hand, the operational creditors have been discriminated. Why? And this is it. The liquidation value being 597.54 crores, the upfront payment suggested by resolution applicant, that is MSL, being less, that is rupees 477 crores, the payment to operational creditors is lower than the proportionate liquidation value, and therefore the resolution plan as approved by the adjudicating authority is against section 30 subsection 2b of the IVC. Now the matter is in the Supreme Court. What are they actually fighting about? We will come to see. The appeal of Maharashtra Seamless Limited was argued by Mr. Kapil Sibal, learned senior counsel, was mainly on the grounds that the NCLAT had exceeded its jurisdiction in directing matching of liquidation value in the resolution plan. MSL in the appeal have sought to sustain the resolution plan, but their prayer in the interlocutory application is refund of the amount remitted, coupled with the plea of withdrawal of the resolution plan. However, their main case, and this is their main case, in the appeal is that the final decision on resolution plan should be left to the commercial wisdom of the committee of creditors, and there is no requirement. Okay, this is what MSL is arguing. There is no requirement that the resolution plan should match the maximized asset value of the corporate debtor. Remember again, MSL offered 477 crores, 532 crores was the liquidation value. This was subsequently increased to 597 crores. Now, NCLT Hyderabad's okayed the resolution plan, saying Maharashtra Seamless is giving 477 crores and 597 is the liquidation value. They okayed it. Padmanabhan, an Indian bank, said nothing doing. When we are getting 490 crores by another resolution applicant, and the value of liquidation is 597 crores, we will appeal the matter to the NCLAT. NCLAT found that yes, this seems to be wrong. The wrong order passed by the NCLAT because you have a better offer compared to MSL. So now, before the Supreme Court, MSL is saying that there is no requirement that the resolution plan should match the maximized asset value of the corporate debtor. In this case, the maximized asset value of the corporate debtor came to 497 crores. Sorry, 597 crores. Now, on the other hand, Mr. Abhishek Mayur Singhvi, learned senior counsel appearing for the two main financial creditors while supporting the main appeal of Mr. Sibal, has resisted the plea for withdrawal of resolution plan and refund of the sum already remitted by Mr. Sibal's clients. Mr. Singhvi has highlighted the fact that the exposure of his clients to the total debt of the corporate debtor is rupees 2060 crores, and his clients being primary creditors to the tune of 87.10% of the total dues. It was his clients who would have suffered loss, if any, on account of resolution plan not matching the liquidation value. Now, on the aspect of withdrawal of the plan, Mr. Singhvi has referred to section 12A of the 2016 code. His submission is that the only route through which a resolution applicant can travel back after admission of the resolution plan is the aforesaid provision, that is section 12A of the 2016 code, which stipulates that section 12A talks about withdrawal of application admitted under section 7, 9 and 10. The adjudicating authority may allow the withdrawal of application admitted under section 7, 9 or 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. Now, it is admitted position that rupees 472 crores has already been remitted to the financial creditors, which was received from Mr. Sibbal's clients. The DB International Asia Limited, having 73.40 voting share in the COC, has also assailed the impugned order on grounds similar to that taken of MSL. Now, therefore, what were the issues before the Supreme Court? Number one was whether the scheme of the code contemplates that the sum forming part of the resolution plan should match the liquidation value or not. The second question is whether section 12A is the applicable route through which a successful resolution applicant can retreat. Now, before we proceed to answer these two questions, we must indicate that before the appellate authority, that is the NCLAT, substantial argument was advanced over the failure on the part of the adjudicating authority to maintain parity between financial creditors and operational creditors on the aspect of clearing dues. Now, let's look at what the Supreme Court observed. According to the Supreme Court, the manner in which the claims of the operational creditors shall be considered in a CIRP has been dealt with by a coordinated bench of this court. In the case of COC of SR Steel India Limited versus Satish Kumar Gupta, decided on 15 November 2019 in civil application numbers 8766, 8767 of 2019. The citation being 2019 SCC Online Supreme Court 1478. And it has been held in paragraph 53 of this judgment, that is the COC versus COC of SR Steel versus Satish Kumar Gupta. This is what was held. However, as has been correctly argued on behalf of the operational creditors, the preamble of the code does speak of maximization of value of the assets of the corporate debtor and the balancing of interest of all stakeholders. There is no doubt that a key objective of the code is to ensure that the corporate debtor keeps operating as a going concern during the insolvency resolution process and must therefore make past and present payments to various operational creditors. Without such operation as a going concern would become impossible. Sections 5 subsection 26, 14 subsection 2, 20 subsection 1, 20 subsection 2D and E of the code, read with regulations 37, 38 of the 2016 regulations, all speak of the corporate debtor running as a going concern during the insolvency resolution process. Workmen need to be paid, electricity dues need to be paid, purchase of raw materials need to be made, etc. This is also reflected in the Supreme Court's judgment in Swiss Robin's case as follows. So now the SR Steel case is referring to the judgment made in Swiss Robin's case, which states that the preamble of the IBC code states as follows: an act to consolidate and amend the laws relating to reorganization of insolvency resolution of corporate persons, partnership firms and individuals in a time-bound manner for maximization of value of assets of such persons. 2. To promote entrepreneurship. 3. Availability of credit and balance of interest of all stakeholders, including alteration in the order of priority of payment of government dues. And finally, to establish the Insolvency and Bankruptcy Board of India and for matters connected to therewith and incidental thereto. Now, as is discernible from the preamble, the preamble gives an insight into what is sought by the code. The code is first and foremost a code for reorganization and insolvency resolution of corporate debtors. Unless such reorganization is effected in a time-bound manner, the value of the assets of such persons will deplete. Therefore, maximization of value of assets of such persons so that they are effectively run as going concerns is another very important objective of the code. This in turn will promote entrepreneurship as the persons in the management of the corporate debtor are removed and replaced by entrepreneurs. When therefore a resolution plan takes off and the corporate debtor is brought back into the economic mainstream, it is able to repay its debts, which in turn enhances the validity of credit in the hands of banks and financial institutions. Above all, ultimately, the interests of all stakeholders are looked after as the corporate debtor itself becomes a beneficiary of the resolution scheme. Workers are paid, creditors in the long run will be repaid in full, and shareholders/investors are able to maximize their investment. Timely resolution of the corporate debtor who is in the red by an effective legal framework would go a long way to support the development of credit markets. Since more investment can be made with funds that have come back into the economy, business then eases up, which leads to overall and high economic growth and development of the Indian economy. Now, what is interesting to note is that the preamble does not in any manner refer to liquidation, which is only availed of as a last resort if there is either no resolution plan or resolution plans submitted are not up to the mark. Even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. This was held in ArcelorMittal versus Satish Kumar Gupta 2019 to SEC 1 at paragraph 83. So now we've gone from SR Steel to Swiss Robbins case to ArcelorMittal. Now, this is the reason why Regulation 38(1)A speaks of a resolution plan, including a statement as to how it has dealt with the interests of all stakeholders, including operational creditors of the corporate debtor. Regulation 38(1) also states that the amount due to operational creditors under a resolution plan shall be given priority in payment over financial creditors. If nothing is to be paid to operational creditors, the minimum being the liquidation value, which in most cases would amount to nil after secured creditors have been paid, would certainly not balance the interests of all stakeholders or maximize the value of assets of the corporate debtor if it becomes impossible to continue running the business as a going concern. Thus, it is clear that when the committee of creditors exercises its commercial wisdom to arrive at a business decision to revive the corporate debtor, it must necessarily take into account these key features of the code before it arrives at a commercial decision to pay off the dues of the financial and operational creditors. There is no doubt whatsoever that the ultimate discretion of what to pay and how much to pay each class or subclass of creditors is with the committee of creditors. But the decision of such committee must reflect the fact that it has taken into account maximizing the value of the assets of the corporate debtor and the fact that it has adequately balanced the interests of all stakeholders, including operational creditors. This being the case, the judicial review of the adjudicating authority that the resolution plan as approved by the COC has met the requirements referred to in section 30 subsection 2 would include judicial review that is mentioned in section 30 subsection 2E, as the provisions of the code are also provisions of law for the time being in force. Thus, the adjudicating authority cannot interfere on the merits of the commercial decision taken by the committee of creditors. The limited judicial review available is to see that the committee of creditors has taken into account the fact that the corporate debtor needs to keep going as a going concern during the insolvency resolution process, that it needs to maximize the value of its assets, and that the interests of all stakeholders, including operational creditors, has been taken care of. If the adjudicating authority, the NCLT, finds on a given set of facts that the aforesaid parameters have not been kept in view, it may send a resolution plan back to the committee of creditors to resubmit such plan after satisfying the aforesaid parameters. The reasons given by the COC while approving a resolution plan may thus be looked at by the adjudicating authority only from this point of view, and once it is satisfied that the COC has paid attention to these key features, it must then pass the resolution plan, other things being equal. Now, we come back to the SR Steel case. It has been further held in SR Steel. Okay, The other argument of Shri Sibal that section 53 of the code would be applicable only during liquidation. Please note it 53 is of the section 53 of the IBC talks about the distribution of assets. It would only be applicable during liquidation and not at the stage of resolving insolvency. Now, section 30 subsection 2b of the code refers to section 53 not in the context of priority of payment of creditors, but only to provide for a minimum payment to operational creditors. However, this again does not in any manner limit the COC from classifying creditors as financial or operational and as secured or unsecured. Full freedom and discretion has been given, as has been seen here and above, to the COC to so classify creditors and to pay secured creditors amounts which can be based on the value of their security, which they would otherwise be able to realize outside the process of the code, thereby stymieing the corporate resolution process itself. Now, submission of the respondent supporting the impugned order of the NCLAT has been in reference to section 30 subsection 2b of the 2016 code. Now, we have taken note of the submission made by Mr. Singhvi that the operational creditors of the corporate debtor come way down in the priority list for distribution of assets under section 53 of the code, informing our opinion over the applicability of clause 38(1) of the 2016 regulations expressed in the previous paragraph. But on this point, a clear guidance comes from the decision of the coordinate bench in the case of SR Steel on the point of dealing with claims of operational creditors. It has been held in that judgment in paragraph 70 of the said report. Now, what does paragraph 70 of the SR Steel judgment say? By reading paragraph 77, the horse that's outside the earlier paragraphs, the appellate tribunal has fallen into grave error. Paragraph 76 clearly refers to the UNCITRAL legislative guide, which makes it clear that beyond any doubt that equitable treatment is only of similarly situated creditors. This being so, the observation in paragraph 77 cannot be read to mean that financial and operational creditors must be paid the same amount in any resolution plan before it can pass muster. On the contrary, paragraph 77 itself makes it clear that there is a difference in payment of debts of financial and operational creditors having to receive a minimum payment being not less than the liquidation value, which does not apply to financial creditors. The amended regulation 48 set out in paragraph 77 again does not lead to the conclusion that the financial and operational creditors or secure and unsecured creditors must be paid the same amounts, percentage-wise, under the resolution plan before it can pass muster. Thus, fair and equitable dealing of operational creditors' rights under the said regulation involves the resolution plan stating as to how it has dealt with the interest of operational creditors, which is not the same thing as saying that they must be paid the same amount of their debt proportionately. Also, the fact that the operational creditors are given priority in payment over all financial creditors does not lead to the conclusion that such payment must necessarily be the same recovery percentage as financial creditors. So long as the provisions of the code and the regulations have been met, it is the commercial wisdom of the requisite majority of the Committee of Creditors, which is to negotiate and accept a resolution plan which may involve differential payment to different classes of creditors, together with negotiating with a prospective resolution applicant for better or different terms, which may also involve differences in distribution of assets between different classes of creditors. But the controversy on there being no provision in the resolution plan for operational creditors is only academic now. Before the appellate authority itself, the successful resolution applicant had agreed to clear the dues. So MSL had agreed to clear the dues of the operational creditors in a percentage at par with financial creditors. Moreover, none of the operational creditors has come before us questioning the legality of the resolution plan. It would appear from paragraph 29 of the order under appeal. Does paragraph 29 of the NCLAT order say? It was submitted that the claims received by operational creditors by the respondent 1 were to the tune of rupees 2 crores 26,70,153 crores, whereas the claims verified were rupees 2 crores 2,88,948 crores. However, it was submitted that the fourth respondent, that's MSL, is willing to pay the verified operational creditors at the same percentage as that of the financial creditors, which is 25%, which shall be paid within 30 days of the successful resolution applicant getting clear and unfettered possession and rights to the corporate debtor. The adjudicating authority has primarily relied on Section 31. Adjudicating authority means the NCLT has relied on 31 of the code in approving the resolution plan. On behalf of Indian Bank and the said promoter of the corporate debtor, reliance was placed on clause 35 of the Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons, Regulation 2016. According to clause 35 of these regulations, liquidation value is the estimate realizable value of the assets of the corporate debtor if the corporate debtor were to be liquidated on the insolvency commencement date. 2. Liquidation value shall be determined in the following manner. A. 2 registered valuers appointed under Regulation 27 shall submit to the interim resolution professional or resolution professional, as the case may be, an estimate of the liquidation value computed in accordance with internationally accepted valuation standards after physical verification of inventory and fixed assets of the corporate debtor. B. If, in the opinion of the interim resolution professional or the resolution professional, as the case may be, the two estimates are significantly different, he may appoint another registered valuer who shall submit an estimate computed in the same manner. And C. The average of the two closest estimates shall be considered as the liquidation value. 3. The resolution professional shall provide liquidation value to the committee in electronic form. Now, the question arises as to whether, while approving the resolution plan, the adjudicating authority, that is the NCLT, could reassess a resolution plan approved by the COC even if the same otherwise complies with the requirement of Section 31 of the Code. Learned counsel appearing for Indian Bank and the said erstwhile promoter of the corporate debtor have emphasized that there could be no reason to release property valued at 597.54 crores to MSL for rupees 477 crores. Learned counsel appearing for these two respondents have sought to strengthen their submission on the point referring to the other resolution applicant whose bid was rupees 490 crores, which is more than the appellant MSL. So, the question again, we go to the question arises as to whether, while approving the resolution plan, adjudicating authority could reassess a resolution plan approved by the COC even if the same otherwise complies with the requirements of Section 31 of the Act. Now, this is what the Supreme Court holds. No provision in the code or regulations has been brought to our notice under which the bid of any resolution applicant has to match the liquidation value arrived at in the manner provided under clause 35 of the Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons, Regulations 2016. This point has been dealt with in the case of SR Steel. We have quoted the above relevant passages from this judgment. It appears to us that the object behind prescribing such valuation process is to assist the COC to take a decision on the resolution plan properly. Once a resolution plan is approved by the COC, the statutory mandate of the adjudicating authority, that's the NCLT, under 31(1) of the code is to ascertain that a resolution plan meets the requirements of subsections 2 and 4 of section 30. We per se do not find any breach of the said provisions in the order of the adjudicating authority in approving the resolution plan. The appellate authority has, in our opinion, proceeded on equitable perception rather than commercial wisdom. On the face of it, release of assets at a value 20% below its liquidation value arrived at by the valuer seems inequitable. Here, we feel that the court ought to cede ground to the commercial wisdom of the creditors rather than assess the resolution plan on the basis of quantitative analysis. Such is the scheme of the code. Now, Section 31(1) of the code lays down in clear terms that for final approval of resolution plan, the adjudicating authority has to be satisfied that the requirements of subsection 2 of Section 30 of the code have been complied with. The proviso to section 31(1) of the code stipulates the other point on which the adjudicating authority has to be satisfied. That factor is the resolution plan has provisions for its implementation. Now, the scope of interference by the adjudicating authority in limited judicial review has been laid down in the case of SR Steel. The relevant passage being para 54, of which we have reproduced in the early part of this judgment. The case of MSL in their appeal is that they want to run the company and infuse more funds. In such circumstances, we do not think appellate authority ought to have interfered with the order of the adjudicating authority in directing the successful resolution applicant to enhance their fund inflow upfront. Now, so that answers the first part of the Supreme Court's issues, the issues before the Supreme Court in this matter. Now we come to the second part, whether 12A is applicable. That means, can MSL now, after being judged as a successful applicant, withdraw from the application process? This is what the Supreme Court holds. So far as the interim application taken out by MSL is concerned, in our opinion, they cannot withdraw from the proceeding in the manner they have approached this court. The exit route prescribed under 12A is not applicable to the resolution applicant. The procedure envisaged is that the said provision only applies to applicants invoking sections 7, 9 and 10 of the code. In this case, having appealed against the NCLAT order with the object of implementing the resolution plan, MSL cannot be permitted to take a contrary stand in an application filed in connection with the very same appeal. Moreover, MSL has raised funds upon mortgaging the assets of the corporate debtor only. In such circumstances, we are not engaging in the judicial exercise of determining the question as to whether, after having been successful in a CIRP, an applicant altogether forfeits their rights to withdraw from the process or not. So the Supreme Court has only said, okay, these were the actions of MSL and therefore they cannot use 12A. The Supreme Court is not going into determining whether after being successful in CIRP, an applicant can withdraw from the process. So we accordingly allow the appeal of MSL and set aside the order of the NCLAT before us. The order of the adjudicating authority passed on 21st Jan is affirmed. MSL, however, shall remit an additional rupees 50,70,237 rupees 50,70,237 to the registered professional for further remittance to the operational creditors as per their dues. This sum has already been offered to the operational creditors as recorded in the impugned order. We dismiss IA 115-118 of 2019 taken out in connection with CA 4242 of 2019. That was this interim application was filed by MSL to withdraw from the application process. The Supreme Court further directed that CA 4967 and 68 of 2019, that is the other applications filed by Deutsche Bank entities, is allowed for the same reasoning. In view of our aforesaid findings and these directions, we are not going into the question as to whether any illegality was committed by MSL as regards to change in the composition of board of directors of the corporate debtor. We accordingly direct the restitution professional to take physical possession of the assets of the corporate debtor and hand it over to MSL. Within 4 weeks, the police and administrative authorities are directed to render assistance to the restitution applicant professional to enable him to carry out these directions. All interim orders stand dissolved and connected applications are disposed of. So with that, the Supreme Court answered the question that it is not necessary that the liquidation amount and the amount which formed part of the restitution plan should be equal. This is a summary of the events which took place. On 12 June 2017, the Indian Bank hauled the corporate debtor under Section 7 to the IBC, Hyderabad, under the IBC to NCLT Hyderabad. On 28 September 2018, An order was passed by the NCLT directing the resolution professional to increase the liquidation value. 16th October 2018, the COC met and increased the value from 432.92 crores to 597.54 crores. Now, on 25th October 2018, the resolution professional finds an application, that is 472 of 2018, before the adjudicating authority seeking approval of the resolution plan as per the decision of the 9th meeting of the COC held on 16th October 2018. Now, this was on 25th October 2018. On 21st January 2019, NCLT Hyderabad in interim application number 472 of 2018 approves the resolution plan considering section 31 of the IBC. On 28th Feb, of course, this is gone to the NCLAT, and NCLAT passes its order. Now wait. This is on 21st Jan. On 28th Feb, order of the NCLAT Hyderabad in interim application 125 of 2019. 125 of 2019 is okay. On 12th of November, NCLT disposes of 637 filed by MSL against the order of the NCLT dated 28th September. On 8th of April is the order of the NCLT, which is challenged in the Supreme Court, and on 22nd Jan 2020, Supreme Court gives its order.